Welcome to the deep dive. We're continuing our journey through the MPP, the Manual of Patent Examining Procedure. Breaking it down section by section.
Yeah, think of these as, well, focus audio guides, making these dense sections a bit easier to grasp.
Exactly. And today, we're diving into Chapter 1800. That's the big one on the Patent Cooperation Treaty, the PCT.
Right. And specifically, we're zeroing in on Section 1803.
Which is titled Reservations under the PCT taken by and notifications of incompatibility made by the United States of America. Quite a mouthful.
It is, but it's crucial stuff. It's basically where the U.S. says, okay, we're part of this international system, but here are specific tweaks or exceptions.
The U.S. House rules for the PCT game, essentially.
You could put it that way, yeah.
So our info for this deep dive, it comes from a summary of 1803, helped along by some AI tools, really just to pull out the key points.
And we definitely need to give a shout out here. A big thank you to Mike Shepard for putting this whole MPP audio series together. Really valuable work.
Absolutely. Couldn't agree more. And before we really dig in, the usual but important bit, this is just for information, for education. It's a summary.
Not legal advice. Seriously, if you need that, you've got to go to the official MPP, talk to a qualified instructor or, a registered patent practitioner.
Definitely. Okay, ground rules set. Let's get into these U.S. specifics under the PCT.
Let's do it.
Okay, so we've got these terms floating around: reservations, incompatibilities. Maybe start with a quick refresher. What's the PCT trying to do, and why would the U.S. even need these special positions?
Sure. So the PCT, at its heart, it's about making international patent filing simpler. That's the goal.
Right. The one application to rule them all? Initially, anyway?
Well, sort of. You file one international application, and that single filing gets you an effective filing date in potentially many PCT member countries that you designate. It streamlines that initial, often chaotic step.
Okay. Efficiency. I get that. But if it's supposed to be streamlined and uniform, why let countries like the U.S. say, well, actually, we do this part differently? Seems counterintuitive.
Yeah, it seems that way, but it comes down to national law. Countries have their own existing patent laws, and treaties don't just wipe those clean. Sometimes a specific PCT rule or procedure bumps up against a country's national law.
Conflict.
Exactly. And that's where these mechanisms, reservations, and notifications of incompatibility come in. They let a country flag those conflicts and say, okay, in this specific instance, our national law takes precedence, while still, participating in the overall treaty system.
Okay, so it's like joining the club but keeping your own rule book for certain situations. Makes sense. Now, what's the technical difference? Reservation versus incompatibility. They sound similar.
They do, but there's a distinction. A reservation is generally about the core treaty itself. It's the U.S. saying, formally, we will not be bound by Article X of the PCT. It's a statement about the treaty text.
Okay, like crossing out a line in the main agreement.
Pretty much. A notification of incompatibility, though. That's specifically about the rules under the PCT, the regulations that help implement the treaty. The U.S. tells the International Bureau, hey, this particular PCT rule clashes with our U.S. law.
And the effect?
The practical effect is that when the USPTO is involved, either as the office you file with initially, the receiving office, or the office examining your application later, the designated office, those specific incompatible PCT rules just don't apply. U.S. law wins out in that interaction.
Got it. Reservation, treaty text. Incompatibility, PCT rules versus U.S. law when the USPTO is acting. Clearer now.
Good. Details matter here.
So let's talk history a bit. Section 1803 mentions a big reservation the U.S. used to have.
Yes, the Chapter 2 reservation. For quite a while, the U.S. declared it wouldn't be bound by Chapter 2 of the PCT.
Chapter 2, that's the international preliminary examination part, right?
Correct. The optional step where an applicant can request an initial non-binding opinion on patentability from an international preliminary examining authority, or IPEA.
And the U.S. just said, nope, not playing that game.
For years, yes. That was their stance via reservation.
But that changed.
It did. That reservation on Chapter 2 was officially withdrawn, happened back on July 1st, 1987. So since then, the U.S. fully participates. The USPTO even acts as an IPEA for certain applications.
Okay, so that's one for the history books. What about reservations that are still active? 1803 points to one under PCT Article 64.3.
Right, this is the main one still in effect. Article 64.3 relates to international publication. You know, the standard PCT process is that the International Bureau, WIPO, publishes the international application 18 months after its priority date.
Okay, standard procedure. So the U.S. reservation carves out an exception.
Yes, but it's very specific. The U.S. reservation under 64.3 says if an international application designates only the United States.
Only the U.S., nobody else.
Exactly. If only the U.S. is designated, then the International Bureau will not publish that application automatically at 18 months.
Why? Doesn't U.S. law generally require publication anyway? Thinking of 35 U.S.C. Section 122B.
Good question. And yes, 122B does mandate pre-grant publication for most U.S. applications. But the key word is most. It's not universal.
There are exceptions to U.S. publication.
There are. For example, design applications filed under Chapter 16 aren't typically published under 122B. And importantly, applications that fall under a secrecy order according to 35 U.S.C. Section 181 are definitely not published.
I see. So because U.S. law itself has exceptions to publication, the U.S. maintains this PCT reservation just in case a PCT application designating only the U.S. happens to fall into one of those non-published categories under U.S. law.
Precisely. It prevents the international system from forcing publication via the PCT route when, domestically, that same application wouldn't be published. It ensures consistency with those specific carve-outs in U.S. national law.
That's actually a really neat example of how national rules drive these international exceptions.
Yeah.
It's not arbitrary.
Not at all. It's very tied to the specifics of the U.S. code.
Okay, that covers the current reservation. Let's shift gears to notifications of incompatibility. Where does U.S. law clash with the PCT rules?
Section 1803 highlights a couple of key areas. The first one impacts you right at the start. If you decide to file your international application at the USPTO, using it as your receiving office or RO.
Okay, filing internationally starting at the U.S. Patent Office. What's the incompatibility there?
Language. The U.S. receiving office is strict. They only accept applications filed in English. Full stop.
English only, no exception.
For filing at the USPTO as RO, nope. English only.
And that clashes with the general PCT approach.
It does. Some PCT rules they mention, 20.1c, 26.3 Taylor, and 26.3 Peter, are more flexible. They basically allow you to secure an international filing date, even if, say, your description or claims are in a different language initially, as long as you provide a translation into an accepted language later on, within a set time frame.
So, under the general PCT rules, I might be able to file partly in German with my RO, for instance, and submit the English translation later.
Exactly. That flexibility exists in the PCT system generally, but
not if your RO is the USPTO.
Correct. The U.S. has notified that those specific PCT rules offering that language flexibility are incompatible with U.S. law and practice for its receiving office function. Meaning those flexible rules simply don't apply at the USPTO as RO. If you want to file your international application with the USPTO, the entire application must be in English on day one to get your filing date. There's no grace period for translation later.
Oh, okay, that's a major practical point. You could lose your filing date entirely if you assumed the general PCT flexibility applied when filing at the USPTO.
Absolutely. It's a classic example of a national house rule overriding the international standard in that specific context. Critical to know.
Definitely. Okay, where else do these incompatibilities pop up according to 1803?
The other main area is later in the process when your international application enters the U.S. national phase. That's when the USPTO acts as the designated office, or DO.
Right, transitioning from the international stage to seeking the actual U.S. patent.
Exactly. Here, 1803 points out incompatibility with PCT rules 49.5 CBIs and 49.5K. These rules deal with certain procedures and requirements related to national phase entry.
And again, they clash with U.S. law.
Yes. They're deemed incompatible with provisions in U.S. national law, specifically mentioning 35 U.S.C. Section 371c2 as a point of conflict. Section 371 is what lays out the requirements to properly enter the U.S. national stage, things like submitting the application copy, translations if needed, fees, and, importantly, things like the inventor's oath or declaration as required by U.S. regulations like 37 CFR 1.497.
So the takeaway is that the specific requirements detailed in U.S. law, like in Section 371 and the related regulations, they take priority over whatever procedures might be outlined in those specific PCT rules, 49.5 CBIs and K.
That's it. When entering the U.S. national phase, you follow U.S. law and regulations regarding entry requirements. You can't rely on those particular PCT rule provisions if they differ from what? 35 USC Section 371 and U.S. practice demand.
Okay, so whether it's the language rule at the receiving office or specific procedures for national phase entry at the designated office, U.S. law dictates the terms when the USPTO is involved, even overriding specific PCT rules.
That's the fundamental point of these notifications of incompatibility.
Let's bring this back to the listener. Why is drilling down into MPP Section 1803 actually important for someone dealing with PCT applications?
Well, it's really about avoiding nasty surprises. If you don't know about the English-only rule for the USPTO as IRO, you might mess up your filing date. If you don't understand that U.S. national stage entry follows U.S. law, not necessarily every nuance of PCT Rule 49.5, you might face delays or rejections from the examiner.
So knowing these U.S.-specific exceptions helps you navigate the system correctly and avoid, well, problems, delays, extra costs, maybe even losing rights.
Exactly. It's about understanding the specific landscape when the U.S. is part of your PCT strategy. Knowing the House rules is just practical risk management.
And presumably, these rules, reservations, they could change over time.
Oh, absolutely. Laws change, treaties get updated, interpretations evolve. Nothing is static forever in this field.
So how do you stay up to date? Where's the definitive source?
The best place is the official listing maintained by the International Bureau of WIPO. That's where countries officially declare their reservations, notifications, declarations under the PCT. That's the gold standard for current information.
Right. Go straight to the source at WIPO. Good advice.
Always the safest bet.
Okay, let's try to wrap this up. We've covered quite a bit in this deep dive on MPP Section 1803. We touched on that historical reservation about Chapter 2 that the U.S. withdrew.
Meaning the U.S. is fully engaged in international preliminary examination now.
Right. And we dug into the current active reservation under Article 64.3, one about no automatic publication for PCT applications designating only the U.S., linking it back to exceptions in U.S. publication law itself.
Like for design apps or secrecy orders, yeah.
Then we hit the incompatibilities, the big one. English only if you file with the USPTO as receiving office, overriding those flexible PCT language rules.
A potential pitfall right at the start.
And the other incompatibility area, certain PCT national phase entry rules like 49.5 CBAs and K don't apply because U.S. law, particularly 35 U.S.C. Section 371, dictates the requirements for entering the U.S. national phase.
Essentially, U.S. requirements rule the day for U.S. national entry.
And pulling back, maybe the bigger theme here from 1803 is just how international treaties interact with national sovereignty. Even in a system designed for cooperation like the PCT, countries retain the ability to tailor their participation based on their own laws.
It's that balance, isn't it? Global rules, national realities.
Which leads us to that final thought for you, the listener, to ponder. These U.S. specifics in the PCT are crucial for patent folks. But think about other international arenas, trade agreements, environmental accords, data privacy standards. Where else might individual countries have these critical house rules or declared exceptions that significantly change how things work on the ground, overriding the general international framework?
Yeah. It's probably more common than we think.
Definitely something to mull over. And one last time, our standard disclaimer. This deep dive, it's based on an AI-assisted summary of MPP Section 1803. It's for education, for information.
It is not legal advice. Please, for real guidance, consult the official MPP, a qualified instructor, or a registered patent practitioner.
Thanks for joining us for this exploration of MPP Section 1803 and the U.S. role in the PCT system.
Hope it was helpful. We'll catch you on the next deep dive.